me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Just speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you now to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true,
Good morning, everyone. How are you? I hope everybody is doing well. It's good to see everyone. Thank you so much for being here. Just a couple of quick things before we get started. In the chat, you'll see I have posted the link to the Verdict Watch stream. I've scheduled that for 5 p.m. today. We'll just move it if we need to. However that goes, I'll just keep rescheduling it until we get a verdict. But you'll have to keep, if I have to change it, right? So let's say we don't get a verdict today by 5 o'clock, okay, and I move it out, and I have to move it to tomorrow at 5 o'clock. You'll have to come back and click the notification again if the live stream is edited. So just to let you guys know that. Second, I want to say today is the 5th year of my channel. I started it May 5th, 2021. I started it with the West Memphis 3 case, and it somewhat feels apropos that on the channel anniversary, we're seeking justice for another child. In light of that, as I do every year, I would like to ask you guys to please, in memory of Christopher Byers, Stephen Branch, and Michael Moore, please turn your porch lights on and leave them on all day, because they didn't come home that night, and they would never come home again. And they are gone, but they are not forgotten. So I just wanted to say that. Also, happy Cinco de Mayo. also. All right. So this morning we're going to get started. We're not going to get right to the opening statements. Geez, Jen, get it together. We're not going to get right to the closing arguments because Miss Anderson has something that she would like to say. She big mad, and we're about to hear about it. Let me rewind it like 2 seconds because I think where I had it isn't quite where we need to be. She's about to say something. All right. So we'll start there. We're going to start with what she needs to say. Your eyes are definitely going to roll all the way to the back of your head when she speaks, but nevertheless, we're going to listen to what she has to say. After she says what she has to say, that there's going to be some back and forth, and then the judge is going to bring the jury in and he's going to read the instructions. They're not incredibly long, so we're going to listen to them because I think it's important to hear the jury instructions, just so we know what it is that they are charged with doing, how they, hold on a second, what they're charged with doing, and what they must find in order to reach a verdict, one way or the other, whether it be the death penalty or whether it be life without the possibility of parole. Oh, thank you, Melissa. I appreciate that. That's the case that got you into true crime. It's the case. Well, I was into true crime before, but this is the case that has stayed with me. I need to get back to it. I just need to still another year, another hope that this will be the year that time management is easier, or I'm better at time management. It's never going to be easy for me, but that I get better at time management. So anyway, let's go ahead and get started. The audio isn't great. You will probably have to turn it up, and I'll probably have to whisper into the mic before I speak, because you guys will have it turned up. All right, here we go. Let's get started.
Understanding that the defense has a motion that you wish to present, Ms. Anderson?
Yes, Your Honor. This time we move that this court preclude the imposition of the death penalty and take it out of the hands of the jury. The basis of this is the pervasive media attention that this case has garnered. There are channels that are on a loop 24/7. It's all over social media, and it's not just a little bit. It's everywhere. We have people outside of the courthouse holding up signs and protesting. We have people online that have created false narratives. That they're flat out lying about what is happening in this courtroom. And I know that this court has given instructions to the jury, and I just don't think it's enough, because this media attention has been so widespread. It is impossible for Tanner to get a fair trial in violation of the 5th and 14th Amendments, and also in violation of the Texas Constitution. This case isn't just local. It's not just statewide. It's not national. There are international newspapers writing stories about it. And so with all of that media attention, our team has received death threats. Our witnesses have received death threats. Our client has received death threats. And so what we're asking the judge to do, and what we're asking you to do, is to preclude the death penalty in this case, because that's the only thing that can remediate the publicity that they have. And the reason that we're asking that is, put yourself in the jury's position. You know that this case is international news. You know that this case is a hot topic. You know that this case has raised such passions that it results in death threats against the defense team. You know all of this. Now imagine you as juror going to church on Sunday, And the person sitting next to me, or sitting next to you says, I knew you're on jury duty. How'd that go? You were gone for 5 weeks. You must have been on that case. I can't believe you did X, Y, Z. So in taking away their ability to, you know, sentence them to life without repercussions from society and from their friends and from their community, that is the only way that Tanner can get a fair trial in this case.
Her argument, okay, look, she is and must defend her client. That is what she is charged with. She took an oath. I get it. I disagree vehemently with her presumption that the only way the jury can have peace is if they ignore what they're going to be tasked with doing and only vote for the death penalty out of fear of retribution. I disagree with that vehemently. I think that this is a last-ditch effort, and I think she's putting it on the record in such a way that if they do come back and find Tanner Horner should receive the death penalty, well, then there you go. They had no choice. There's so much pressure from the media. There's so much pressure from society to find him, to sentence him to the death penalty, that this was the only thing that the jury could do. It may not be how they actually felt or wanted, what they wanted to happen, each individual juror. That's ridiculous. I will say this. Death threats to the witnesses, the defense witnesses, death threats to the defense team, and death threats to Tanner Horner. While I understand how angry this case has made people, specifically at Tanner Horner, Tanner Horner is the only person in this whole case that is accountable. He's the one that made the decisions, took the actions, did the things that landed him here. These attorneys are here because they were appointed to Horner. Okay? This is their job. The defense witnesses, the civilian witnesses for the defense were there because they were subpoenaed. They had to be there. They didn't have a choice. It is not their fault that they knew Tanner at some point, or that they're related to him by blood. That's not their fault. They didn't ask for this. So the death threats is ridiculous. That is out of hand and unnecessary. What is the point of that anyway? Tanner Horner's up for the death penalty. So what's the point? It's ridiculous, and it should not happen. What people are outraged over, and I think why this has gotten to the point that it's gotten, I'm not excusing death threats. Those are never okay. It's completely unacceptable. We live in a civilized society, and we don't need to be acting like that. It's ridiculous. It's unnecessary. We shouldn't be doing that. Nobody should be doing that. The reason that people are so outraged is because for the last 3 years, the public, and I understand why this had to be, the public had an assumption of the crime. I don't want to say it. Well, it was an assumption based on what was publicly available, specifically the arrest affidavit. Okay. We had a presumption. That's a better word. We had a presumption of what this crime was. And only recently, and I know it seems like it's been a long time, it has been a month, but over the course of that month, more and more and more details, horrific details of the agony, the pain, the terror that 7-year-old Athena Strand suffered have come out. And people are angry. And rightfully so. We have a right to be angry. What we don't have the right to do is to take justice into our own hands. The courts are where justice will be served. So I understand why she feels the need to put this on the record. I don't think that it's going to work. I don't even think that that if, well, I mean, spoiler alert, the judges, I mean, they go forward to closing arguments. So obviously he didn't take it out of the hands of the jury. Okay. So what she really wants him to do is to take the death penalty off the table and sentence Tanner himself. The judge cannot issue a sentence of the death penalty in Texas. Only a jury can do that. Okay. So by default, if he removes the death penalty as a penalty option, then he can sentence Tanner Horner to life without the possibility of parole. And she's claiming that that is the only way that Tanner Horner can get a fair trial. The truth of the matter is, I believe this jury has taken their oath seriously. I believe that they are not willing to do, they understand the gravity of the situation and are not willing to do anything to compromise the verdict later on down the road, even or today. I believe that they have stayed away from the media. What could the media tell them that they don't already know? They've heard it all. All right, let's keep going.
The court daily, even though it's not in the record, the court daily has admonished the jury in the jury room to stay away from media, to the point of last week, I didn't tell the lawyers this, one of the jurors asked me, is the case still getting a lot of attention? So based on that question, I am satisfied that the jury has been following my instructions to stay away from the media. Your request is denied. The jury is present. Are both sides ready for the jury?
Ready.
Defense? All right, let's go.
Sarah says, we had clues and our minds filled in the blanks, but only when we cleared the lens via trial did we realize that we were peering through a smeared peephole for the past 3 years. I think we all had questions. I think we all wondered because there was such a disconnect from it. It just did not make sense. And not that the murder of a child ever makes sense. It's just that the details that we knew publicly back in 2022, 2023 are just, it's such a disconnect, right? And then we all wondered. And then we learned the truth, which is why I stream trials, because I think it is incredibly important to, particularly in cases that receive a lot of attention. I think all cases are important to watch and go to trial. I mean, I've covered high profile cases and I've covered cases that aren't high profile. But because during those first few days of somebody going missing or a crime being reported, there's so much speculation. And then if law enforcement isn't incredibly forthcoming with all of the things, all of the details. The speculation gets even more. Then law enforcement gets, bashed and all of the things. So I think it's really important, particularly in these high profile cases, that you watch the trial if you're able to. If they stream it, it should be watched, because then you understand the details of the investigation. You can see firsthand what law enforcement did or didn't do, why they did something and didn't do something else. And then you can assess the type of the quality of the investigation from that point. But you can't, how can you assess the quality of an investigation when you have no idea what the investigation entailed in the first damn place? So, yeah, that's why we watch this. All right, here we go.
Everyone may be seated. Good morning. Members of the jury, the defendant Tanner Lynn Horner stands charged by indictment with the offense of capital murder, alleged to have been committed in Wise County, Texas, on or about the 30th day of November 2022. To this charge, the defendant has pleaded guilty. The defendant has entered this plea, and the court hereby instructs the jury to find the defendant guilty as charged in the indictment. Your verdict must be by a unanimous vote of all members of the jury. In deliberating on the case, you shall consider these instructions as a whole, and you must not refer to or discuss any matters not in evidence before you. Our law provides a defendant may testify on his own behalf if he elects to do so. This, however, is a privilege accorded to the defendant, and in the event he does not testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has not testified, and you are instructed that you cannot and must not refer or allude to this fact throughout your deliberations, or take it into consideration for any purpose whatsoever as a circumstance against the defendant. When you go to the jury room, the first thing that you should do is select one of your number as your presiding juror, who will help to guide your deliberations and will speak for you here in the courtroom. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, such as Facebook, LinkedIn, Instagram, YouTube, or X, to communicate to anyone any information about this case, or to conduct any research about this case until I accept your verdict, if any. If at the conclusion of your deliberations, the presiding juror should sign the verdict form, and I am requesting whoever the presiding juror is, if he or she will print their name beneath the verdict form and put your juror number next to the signature. If you need to communicate with me during your deliberations, the presiding juror should write the message, ring the jury call button on the wall, and give it to the bailiff. I will either reply in writing or bring you back into the court to answer your message. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to their testimony, but you're bound to receive the law from the court which is herein given and be governed thereby. And I've signed the instructions as judge. The last page of the instructions contain the verdict form. Says, we, the jury, find the defendant, Tanner Lynn Horner, guilty of the offense of capital murder as charged in the indictment. The presiding juror should sign his or her name on that line beneath the verdict form. All right? If you retire to your jury room, buzz me when you're ready.
All right, so the way this goes, you just heard the judge. The jury must find him guilty of capital murder. Okay? Then they can go on to the next part. All right, so that's what they're going to do. They're going to find him guilty. He pleaded guilty. And, what's interesting to me is that Tanner Horner never took the stand in the penalty phase of this trial, right? However, Tanner Horner did testify in a way. That video from the inside of that truck is testimony. It's testimony by him of what he did, and it's testimony by Athena of what she endured. They are doing a closing, Melissa. It's after this. They got to find him guilty first because he pleaded guilty. So they got to come back. They've got to sign the jury form saying that they find him guilty of capital murder. Then the judge will read the instructions for the next part of it, which is this penalty phase. And that, sorry, I have hiccups. And then we'll do the closing arguments. Come on. All right, here we go.
Yep.
Okay. And also, to Sarah's point in the chat, Sarah Bellin served on a jury. These jurors understand the enormity of the situation. The fact of the matter is that when the death penalty is potential punishment, there's additional voir dire of the jurors, and it's extensive. It takes a long time. And at the end of the day, the jurors are selected because they understand the gravity, the enormity of the situation, and they are willing to at least consider taking somebody's life. Okay? Sentencing them to death is taking somebody's, that's a heavy burden in and of itself. Even though they're not the ones that are actually taking his life, they're the ones that are saying, you know what, this defendant, the crime was so egregious, there's no mitigating circumstance or circumstances. This person, the only punishment befitting the crime is the death penalty. And they have to be willing to consider that. So I feel like Miss Anderson standing up and acting and making basically saying that the jury's only going to find Tanner Horner deserves the death penalty because of fear of reprisal is ridiculous. They're the ones that have to sleep with their verdict. Good morning, Michelle. Good to see you. Good morning to all of you guys just joining us. Here we go. Let's go. I'm not going to talk that much.
Everyone may be seated. Mr. Presiding Juror, it's my understanding that the jury has reached the verdict. Is that correct? Yes, sir. And paperwork, please, Deputy. Verdict says we, the jury, find the defendant Tanner Lynn Horner guilty of the offense of capital murder as charged in the indictment, and it is signed by the presiding juror. Does either side desire to oppose?
No, sir.
All right. Members of the jury, I will now read you the instructions on punishment. Lawyers will then make their closing arguments.
At the conclusion of the closing arguments, you retire to your jury and continue deliberations on punishment. Okay? Members of the jury, the defendant, Tanner Lynn Horner, has been found guilty by you of the offense of capital murder. Therefore, it now becomes your duty to determine the punishment to be assessed against the defendant. Punishment for the offense of capital murder is by imprisonment in the Texas Department of Criminal Justice for life without parole or by death. In order for the punishment to be assessed, 2 special issues are being submitted to you. Before answering these special issues, if you can, you will consider the following instructions. It will not be proper for you to arrive at your answers by lot, chance, or any other random method. Your answers, if any, must be arrived at by a full, fair, and free exchange of the opinions of each individual juror. Each of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. Do not give up your honest beliefs as to the weight or effect of the evidence. The prosecution has the burden of proving that the answer to special issue number special issue number 1, no. You may not answer special issue number 1, yes, unless you agree unanimously. You may not answer special issue number 1, no, unless 10 or more jurors agree. The members of the jury need not agree on what particular evidence supports a negative answer to special issue number 1. If any juror has a reasonable doubt as to the answer to the above special issue, the juror shall vote no as to that issue. In deliberating on special issue number 1, you shall take into consideration all of the facts shown by the evidence admitted before you in the full trial of the case, including evidence of the defendant's background or character or the circumstances of the offense that militates for or mitigates against the imposition of the death penalty and the law as submitted to you in this charge. Only if the jury unanimously answers special issue number 1, yes, will the jury next consider special issue number 2. Otherwise, the jury shall not answer special issue number 2. Special issue number 2, whether taking into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole, rather than a death sentence, be imposed. You shall answer special issue number 2 either yes or no. You are instructed that you may not answer special issue number 2 no unless you agree unanimously. You may not answer special issue number 2 yes unless 10 or more jurors agree. The members of the jury need not agree on what particular evidence supports an affirmative finding on special issue number 2. You shall consider mitigating evidence to be evidence that a jury might regard as reducing the defendant's moral blameworthiness. You are instructed that if the jury answers that a circumstance or circumstances warrant a sentence of life imprisonment without parole rather than a death sentence being imposed, the court will sentence the defendant to imprisonment in the Texas Department of Criminal Justice for life without parole. A defendant sentenced to confinement for life without parole is ineligible for release from the Texas Department of Criminal Justice on parole. The state has introduced evidence of extraneous crimes or bad acts other than the one charged in the indictment in this case. This evidence was admitted only for the purpose of assisting you, if it does, in determining the proper punishment of the offense for which you have found the defendant guilty. You cannot consider the testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other acts if any. Our law provides a defendant may testify on his own behalf if he elects to do so. This, however, is a privilege accorded to the defendant, and in the event he does not testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has not testified, and you're instructed that you cannot and must not refer or allude to this fact throughout your deliberation, or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You have heard evidence that the defendant made an oral and recorded statement on December 2nd, 2022, and on December 7th, 2022. If you find the defendant did make the statement, you may consider that statement against the defendant only if you resolve a preliminary question in favor of the statement. An oral recorded statement by a defendant made as a result of custodial interrogation may be considered against the defendant only if before the statement, but during the recording, 1, the defendant was warned that he has the right to remain silent and not make any statement at all, and that any statement he makes may be used against him in his trial. Any statement he makes may be used as evidence against him in court. He has the right to have a lawyer present to advise him before and during any question. If he is unable to employ a lawyer, he has the right to have a lawyer appointed to advise him before and during any question. And he has the right to terminate the interview at any time. And 2, the defendant knowingly, intelligently, and voluntarily waived the rights set out in the warning. Therefore, you may consider any statement you believe the defendant made on December 2nd, 2022, or on December 7th, 2022, only if you first all agree that the state has proved, beyond a reasonable doubt, that before the statement, but during the recording, the defendant was given the warning set out above, and knowingly, intelligently, and voluntarily waived the rights set out in the warning. If you do not find that the state has proved these things beyond a reasonable doubt, you must disregard and not consider for any purpose any statement the defendant may have made. If you do find the state has proved these things beyond a reasonable doubt, you may consider the evidence that the defendant made the statement and give that evidence whatever weight you believe appropriate. In deliberating on this case, you shall consider these instructions as a whole, and you must not refer to or discuss any matters not in evidence before you. You must not consider nor mention any personal knowledge or information you may have about any facts or persons connected with this case which is not shown by the evidence. You shall not consult law books or anything not in evidence. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case or any witness therein. And no juror is permitted to communicate to any other juror anything he or she may have heard regarding the case or any witness therein from any other source other than the witness stand. When you have arrived at your answers for each of the special issues today, you may use the attached form provided at the end of these instructions. Any further communication with the court must be in writing signed by your presiding juror through the bailiff. Do not attempt to talk to the bailiff, the attorneys, or the court regarding any question you may have concerning the trial of the case. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given to the testimony, that you're bound to receive the law from the court which is herein given and be governed thereby. And I sign the instructions. The last 2 pages of the instructions contain the answers to the special issues. Special issue number 1, whether there is a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. There are 2 possible answers. We, the jury, find the defendant unanimously beyond a reasonable doubt that the answer to special issue number 1 is yes. Or we, the jury, have at least 10 jurors with a reasonable doubt as to the matter inquired about this special issue and find that the answer to this special issue is no. If either one of those is the verdict of the jury, the presiding juror should sign the appropriate verdict form. Only if you answer yes to question number 1 unanimously will you answer special issue number 2. Otherwise, you will not answer special issue number 2. Special issue number 2, whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that the sentence of life imprisonment without parole rather than the death sentence be imposed. Again, there are 2 possible answers. We, the jury, find the defendant that the answer, unanimously find the answer to special issue number 2 is no, or we, the jury, have at least 10 jurors that agree the answer to special issue number 2 is yes, and find that the answer to this special issue is yes. The presiding juror should sign his name on the space beneath the appropriate verdict form. Mr. Staple.
Thank you, Your Honor. It's been a heck of a month. I want to thank you up front for being so attentive and giving us your time away from home, away from your families, away from work. We appreciate that. The way it works today is I've got a few things to say. The defense will have a few things to say, and then I will finish, and you will get the charge of the court that the judge just read you. I'm not going to go through all the evidence in the case. I don't have enough time. The judge gives me an hour, and then I get the hook, so to speak. But I do think there are some things that are important. And this is the number one thing that I think is most important right here. This is what's most important. This is why we're here. The picture sat in my office for months. And I looked at it every day. And it's a reminder on those days, why do I get up again? Why do I keep doing this? And this picture was taken, she didn't know she only had 4 days left to live. So that picture was taken. When that picture was taken, I didn't know that 6 days after that, I'd be talking to my sheriff. And you heard from him, a former Texas Ranger, a fairly grizzled veteran of law enforcement, that I'd be sitting there with him and not a dry eye between us. I knew then that I would be here in front of you. But why are we here? We're here for her. We're here for her memory, her voice, a little bow on her head, smile on her face, love in her heart. That's why we're here. She can't see justice. We're here for her. When you all got qualified and we went through the whole process, talked about a lot of things. And one of the things that I think we talked about is the death penalty, and a lot of people are reluctant on that, and we should be. And it should be used in only the most extreme cases. Now, those cases, intentional, cold-blooded, planning, or premeditation, victims that can't help themselves, children. Cases where the victim is sexually assaulted prior to their death. Cases where there's no mercy shown to the victim. Cases like this. This is what, and the reason why that Texas keeps the death penalty here. This is why. This is the type of case. And I'm going to tell you, Tanner Horner is proof why parents hug their children a little tighter. He's proof of why children are nervous to go play outside. He's proof of why there's evil in society and we can never turn our back. Now, 2015, May 23rd, Athena, she was born. 18 days from today, she turned 11. 18 days. If you remember on opening, we talked a lot about past tense. And I'm not even trying with the glasses anymore because my eyes are smoked after this trial. We talked a lot about wood. We talked about past tense. And I think it's important. We've heard a lot about people's past and but I think it's important to talk about what would have been. You know, when we talk about Athena, I feel like we want to talk about when she would have graduated. She would have been a Paradise Panther class of 2033. She would have celebrated her birthday party in 18 days. And I can promise you there would have been an overload of pink. That's all wood. Okay. The other questions we look at is the future. We look at, you know, when you look at it, you ask yourself, you know, who would she marry? Who would be her first boyfriend? Real boyfriend. You know, some things that I thought about is what kind of shoes would she wear under her wedding dress? Those things are important. Who would she marry? Right? What kind of job would she have? That's what's important here. Her future. And the fact that Tanner Horner cut that short. Brutally cut that short. So that's why we're here today. Tried to do all this by memory. It just doesn't happen. We've been here 5 weeks now. It just doesn't happen. So the big thing here is this case is going to require a tough choice. We all know this. But the right thing is often the toughest choice. Now, we're taught as baby lawyers, we're supposed to get up here and bring all the fire and brimstone. And I can assure you, I can generate some fire and brimstone. But this isn't the case for it. I can't do any more or say anything more than what you've already seen on that screen. There's nothing I can do. There's no amount of fire and brimstone. There's no amount of jumping up and down and being like that could ever come close to what you've already seen. And I'm not even going to try. The evidence in this case, I'm not going to go through it because it is massive. But the big point of all of this evidence is this. If you start at the beginning, you know the facts. You heard the facts. When I came up here in opening, I told you I was going to put you as close as you could be to actually being there. And I did not lie. In this case, the evidence, you know, we talked about the worst of the worst and the cases that like this, cases that have planning or premeditation. Don't discount the fact that somebody decided to cover up the camera an hour before, 2 days in a row, on exactly the same road with 2 different locations with 2 little girls that were there. You saw the videos. My suspicion is those husband girls would have been first if the parents hadn't come out. They were first. Only when that didn't happen, Dana was second. So the evidence speaks for itself. You know, when we talk about planning, it's not all just pre-planning. It's the understanding of what you're going to do after. You know, for somebody that is having some form of catastrophe and inability to think or solve problems, out of all the random roads you could have chosen to go and sexually assault Athena, you drive right to it. You know the road, you know what's going on, you know the bumps, you know what's there. You don't pick some random road. You go to where you know it's secluded. That's planning. That's not somebody having a catastrophe and doesn't know where they are. Okay. So we know what he wants. We know because you heard it. One.
Judge, can we approach?
Can all the members of the jury see the board?
We know what he wants. And we know what's coming. Athena didn't know what was coming. He knows what's coming. That's not the eye, that's not the look of someone who doesn't have a plan, doesn't have motivation, that hasn't thought this out, that hasn't fantasized about this. That's the look of a predator right there. Now, about the evidence, you know what happened. I'm not going to go over that anymore. There's a couple of things here that I think are important. I talked to you about DNA, and I think DNA is important. The only acceptable answer in this case is that Tanner Horner was excluded. That's the only acceptable answer. And that's not the answer we have. Period. It's not that, well, we found some DNA, it was his, but, maybe it's not enough. It's like when Dr. Ryan got up there and said, well, he's not a pedophile. It only happened one time. I beg to differ with that. Now, when we talk about the murder and what happened, you guys heard it. And I don't want anybody to ever forget what kind of warrior that little girl was. I don't know if anybody could have withstood what she withstood. Over and over again. I don't know anybody that could have withstood that. He can choke her, he can beat her, he can do it over and over again. But what do we know? We know the end result was right here. This is what it took. That's what it took to beat the life out of her. And I think that is key to this entire case. If the facts were not bad enough, if the sexual assault wasn't bad enough, the level of violence that one person can inflict on a child, including stomping them with a pair of shoes, and I wonder where that tread-like print came from anymore, because we know. Now, like I said, the defense is going to get up here after me. They're going to have some things to say as well. That's how it works. Okay. But what I anticipate is going to be a continuation of what you've already heard. His brain's broken somehow. He's got all these conditions. He's got all these ailments, all these things. He may have some or part of those. Apparently, according to Dr. Young, he even got low T. We even got the lead paint guy. Now, I don't know about the lead paint guy. I don't know if it works or not. I don't know if his little homemade zapper works or not. I honestly don't know. But what I do know is this. If you're going to come in here and try to convince us that somebody has all this lead in their system that's causing all the problems, why do you test anybody else? I mean, if you want us to believe you and all this stuff's going on, why don't you test the other people in the house? I don't think you want to know the answer. That's why you don't do it. So when we get up here, it's going to be a lot of talk about second chance. There's going to be a lot of talk about, maybe mercy. There's going to be a lot of talk about, his deficits and disabilities and things of that nature. But let's remember this. Everything they're telling you is an excuse. You know how I know it's an excuse? Because it took 6 or 7 experts and $500,000 to come up here and tell you it's not an excuse. That's how you know. If you've got to work that hard to try to prove that some kind of excuse, we know what the answer is. They're trying to get you to excuse his conduct. They're trying to get you to be less angry or less blameworthy on somebody for their conduct. I submit to you the truth and the facts and circumstances are what's most important. What he did is most important. Now, in looking at all of this, if you want mercy and you want somebody to consider giving you life when you gave no life here, when you gave no mercy here, what does it start with? I like to think it starts with the truth. I like to think it starts with not lying. I like it things to start with, if you have experts and you're being interviewed, not continuing to fabricate stories, not continuing to lie to you, not continue to try to cover, not continue to try to shade this or change the narrative. I think that the difference between wanting mercy and earning it are two separate things. So, now, what you've heard for the past 2 weeks is that the person driving that vehicle, you can see it right here, this person right here driving this vehicle. You've heard for the last 2 weeks every form of ailment one could possibly have. And you heard about the last 2 weeks how that person can't cope, has stress, has the inability to do basically anything on the earth whatsoever, that essentially is incapable of doing anything. If you have any doubt about that, watch the 8 minutes of this video right here, from when he pulls in to Athena's driveway until he covers up the camera. If you have any doubt about somebody's ability to do and participate and be out in the world, watch that video. Because it's real, real clear. That's an individual who knows what they're doing. That's an individual who's hunting. That's an individual who's looking around and understanding what's around them. That is an individual who is absolutely lethal. That's an individual who targeted somebody, found somebody, tricked somebody, got him into the vehicle. You all saw when he took his hand and he put it over her mouth. He knows what's coming. You all saw right here. You all saw right here. Bungee cords, trying to tie somebody up. You all saw that. This is not an individual that's on some form of stress-fueled catastrophe. And the cocaine nonsense, come on. Just another lie. Just another lie. But guess what? When you know that you've been caught covering up the camera, and you know you've been caught, what do? You come up with another lie that fits your narrative. That's what you do. And that's what's happened in this case. It's lie upon lie upon lie. This person driving this vehicle, cool, calm, and obviously lethal. So, are you going to believe what you hear up here, that this person is basically can't even get up in the morning? Or are you going to believe your eyes and what you see and hear? The only sentence in this case that gives justice to her is answering those two questions. Yes and no. Thank you, Judge. Mr. Goble.
So it is my understanding, based on what took place at the end of the day yesterday, where the judge and the attorney spoke about like how long they were going to need to be given, etc., that Mr. Goebel and Miss Anderson are going to split closing arguments. Thank you so much, Karen. Karen says it was an honor to be here. You're not leaving, are you? It was. Are you? You're talking in past tense, babe. I know what you meant, and I appreciate it. Thank you so much. Thank you, everybody, for being here. I appreciate it. This was another hard one, but we're on our way to justice for Athena.
I do want to start by echoing what Mr. Stanton said. This jury, I think about every one of you, said something to the effect of, you didn't really want to be here, but if it was your civic duty, you would do it. And I appreciate you all showing up every day, attentive, punctual. It was hard to pay attention to everything. I know we put on a lot. And not every jury does that, frankly. And you all have been really impressive, and I appreciate it. Now, you already did the first part, rendering the verdict that he's guilty of capital murder, according to his plea. That means he will spend the rest of his life in prison. We know that. The prosecutor gave you the list of different charges. Whether or not that gets a death penalty is not about comparing different capital murders. It's not about whether comparing what happened to Athena to a mass murder, or to the murder of a police officer or a judge or anything like that, and which is worse. We've already told you that Texas law is always satisfied with life without parole for a capital murder. In this case, any case, the worst case you can imagine. We talked about what you would do in the punishment phase. It's different than the fact-finding phase. It's different than that guilt innocence phase. I told you that it's going to be your individual moral judgment. Now I want to point out to you in your punishment instructions, the judge included some language in here. That's what we told you before. Each of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. Remember, we talked about what deliberating means. We're attorneys. If we meant for you to argue, to fight, to berate each other, we know what those words are. The judge put it, an impartial consideration of the evidence with your fellow jurors. But he also added, do not give up your honest beliefs as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of answering the special issues. The special issues are how we decide whether or not Tanner gets a death sentence. I am completely satisfied that all of you took your oath and meant it. Now what that means, and I'm only going to talk about special one, is that you have to apply this. Whether there's a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. And Susan and I explained to each one of you when we talked individually that this is where that individual moral judgment comes in. That you're going to define what these terms mean. What a probability is. What a criminal act of violence is. What continuing is. And I know the prosecutor and a lot of you gave you some suggestions that could be ongoing for continuing acts of violence, could be something, assault, things like that. But that's ultimately going to be up to you. We did talk about society being prison, a more secure society than any of us live in day to day. And I'll get back to that in a minute. But remember, this proof has to be beyond a reasonable doubt. So I told you before, I gave you the sample. All that language is still here. Prosecution has the burden of proving that the answer to special issue number 1 is yes, beyond a reasonable doubt. Frankly, they spent their 2 weeks proving the case that he pled guilty to, talking about lying and waste of resources. They didn't put on any evidence that Tanner Horner is going to be a continuing threat to society in prison. Nothing. Your instructions are you may not answer the special issue number 1 yes unless you agree unanimously. You may not answer it no unless 10 or more jurors. We went over that, 10, 11, or 12 to answer the no. But I just read to you, you're not to give up your individual moral judgment. That's what you need to bring back to the court. So if you don't meet that 10, if you don't meet that 12, that's fine. The judge knows what to do. We've already told you leave that blank, have the foreperson sign it, and the judge will take care of it. There's no mistrial. There's no hung juries. This is capital punishment and it's different. I do want to talk a little bit, even though Tanner did plead guilty, I do want to talk a little bit about the prosecution's case. He told you his theme was lying. Brought it up again. There's nothing about lying on here. Frankly, go back to creation, lying was humans' first reaction to getting caught doing something bad. Deputy Amy.
All right. I'm sorry. I need to cut in here. Is this really where you want to go, Mr. Goebel? This is what you want to leave as an impression with the jurors, that everybody lies? While that may be true, I think to an extent everybody does lie, okay? Not everybody lies to cover up the sexual assault, torture, and murder of a 7-year-old little girl. So I cannot, this is, again, all those thoughts swimming around in that head of yours, and this is the one that escaped. What do you think, Mac? I know, Mac. Can you believe this bullshit? All right. I try not to interrupt the closing arguments, but that one just went all over me, and I'm sorry. So here we go.
Handled every piece of physical evidence in this case. Handled every photograph. She did something wrong, and she lied, and she lied again, and she lied again, and made it all worse. This isn't about lying. Ranger Espinoza told you he lies as an interrogation technique. He lied in this case to get the information he wanted. This case isn't about lying. You don't get the death sentence for lying. There was a theme with our experts. Every one of them, they asked them about insanity. Tanner pled guilty. We didn't raise the not guilty by reason of insanity defense. That was a waste of time. They argued that Tanner wasted resources. But they played through that December 7th video. Now, had I been his attorney on that date, I would have wanted to be there. I don't think it's right that you interrogate somebody after they have an attorney appointed for them, or when they're asking for an attorney. But they did it anyway, and what he did was offer to plead guilty, to plead no contest, to accept the minimum of life without parole. And he wanted out for Christmas, and they mocked it. He wanted out for Christmas with his son, and they made fun of him. Like that wasn't reasonable. He could have been out that day if he'd had cash. He had a bond. Him going home from Christmas was not unreasonable. Beginning a negotiation with an offer and an ask is what happens every time. Most cases in America don't go to trial. They're pled out. Now the answer can be, no, we want you to plead guilty. No, we're not going to agree to a lower bond. That's what negotiation is. Frankly, if you go to buy a house tomorrow, you're going to make an offer of what you're willing to pay for it, and you're going to ask for the refrigerator, or for clothing costs, or for something else. And the other party may say no, and you may still end up buying the house. This case could have been over in December of 2022. No one took it seriously. I don't even know if it went to the prosecutors. Definitely didn't get to a judge. That wasn't ridiculous. Now, yeah, you've seen his videos. Everything Tanner does is off. So maybe they didn't take him seriously because when he made this offer, he sounded weird. Oh, of course we're not going to let you out for Christmas. He could have been out that day. $1.5 million bond. It's America. If he had cash, he would have been walking. So to mock him for it is frankly, it's ridiculous. I deal with a lot of clients that don't know how to negotiate. That's why the attorney should have been there. The other thing that's kind of frustrated me in this case is and I hate to belabor it, the kind of the misrepresentation of some of the evidence. Going back to the medical examiner's report, and you have all these reports. So if you're interested in any of them, you want to look at it, you can. Medical examiner testified and put in her report, the external genitalia, anus, and perineum are unremarkable. No trauma is appreciated on the vagina, or the vaginal labia, or within the vaginal vault. The vaginal hymen is present, intact, and unremarkable. No trauma is appreciated within the anus or the perianal skin. Prosecutors and medical people are allowed to tell you that evidence of sexual assault in a medical examiner's report is proof, but absence of it is not disproof. That's illogical, but that's how that is. No fractures were palpable within the facial bones. No fractures anywhere in her body. The other thing that isn't in her report, but she testified to, was that her autopsy tech did the DNA, the swab for the DNA. She testified here that her tech swabbed inside and out. There are no swabs of inside the cavities. There weren't separate swabs. Why that matters is when you actually read the DNA reports, and I'm only going to bring up 3 of them because that's all that really mattered. There's a lot of reports that get DNA on his own clothes. Whatever. Starting with this April 19, 2023 report. Casada testified to it. She had to do it within 90 days to see if this was a sex assault case or not. The phrases epithelial cell fraction and sperm cell fraction don't mean what you think they mean. It tells you right in this report. Casada testified to it. Epithelial cell fraction could contain semen. Sperm cell fraction can contain skin cells. The notations of epithelial cell fraction and sperm cell fraction are for sample tracking purposes only and are not intended to indicate the source of the DNA. This April 2023 DNA analysis, the likelihood ratio indicates support for the proposition that the suspect is excluded as a possible contributor to the profile. So this first DNA sample excluded, it was someone else's DNA. We also put in here, remember Casada testified to this, and I think Ferreira too. The only way to figure out if a sample is semen is to look under a microscope for sperm cells. They didn't do that. This first report in April 2023 tells them, please note, that no testing to confirm the presence of semen was conducted on the vaginal swabs. If testing to confirm the presence of semen is needed, please contact this laboratory for instructions. That's how you would have figured it out. Nobody did that. Then they come back with a supplemental report. This update is not due to an error in previous testing. Just a repeat of that April 2023 report 2.5 years later. So 2.5 years later, and they tell you, which is fair, I guess, that this is just wordplay. At the request of the Wise County District Attorney's Office, this supplemental report communicates the results using new guidelines implemented on November 28, 2023, involving the addition of verbal scale qualifiers. So they come back around, print the same report, but this time they change it to the likelihood ratio indicates limited support for the proposition that the suspect is excluded. And they don't include the language about how to check, how to find out if this is sperm or not. Probably because they already did the same report on the WideStar. This is the DNA WideStar from September 15, 2025, 2.5 years after the first one. Remember Casada testified she didn't take those swabs. She's not saying it's epithelial skin or skin cells. She's not saying it's semen cells. The swabs were taken externally. Unfortunately, we know Tanner undressed Athena. Tanner covered Athena's mouth. This report doesn't tell us anything more than that. I had a brief discussion with Ms. Casada about how little DNA was there. It's an infinitesimally small amount. Every time it got brought up, I tried to object that these were somehow proof of sexual assault. They're just not. The medical examiner's report and the DNA reports. The actual issue, whether or not he's going to be a continuing threat to society. We started our case with Professor Eden, who has actually done research on what matters, what can be predicted, what isn't predicted. Actually looked at Texas inmates who had people testify that they were going to be a future danger. Some of those people were on death row, some had life without parole, some got exonerated. Proven they weren't guilty and they went home. But all of them had people saying that they were going to be a future danger without any research to back it.
All right, let me stop you right there. I think that the results pertaining to inmates who later turned out to be exonerated, you shouldn't use that as a comparison. Because quite frankly, if you are actually innocent and you are in prison, what are you going to do? You're going to sit there. You're not going to do anything to compromise your appeals. And if you are violent inside of prison, you catch new charges. Shut up. That is a dumb argument. Don't make that argument, including exonerated people who were eventually exonerated. The fact of the matter is we can't predict who's going to be violent inside prison and who isn't. But at the end of the day, I'd rather err on the side of caution. Shut up.
Now, Professor Williams did say there are things that do matter. If you go to prison the first time between 18 and 21, if you have a lower education, don't have at least a high school diploma or a GED. If you're a member of a gang on the outside or when you get in, there's a higher likelihood there's going to be violence. And if you've been to prison before, or you've committed violence while you're in prison. Which would seem like common sense, but he also went through the hard work of researching it and teaching people how to look at this. For Tanner, none of those apply. Tanner was 31 when he went to prison. Tanner is not the person you see on the news who's been arrested 31 times and released despite it being violent crimes. This is Tanner's first time. He has his high school diploma, non-member of a gang, obviously. 2 jails, plenty of people, female, male, volunteers, religious meetings. You've heard, obviously, every expert we brought up here, he went to visit them, but transported for his brain scans, transported between the jails, transported to court. No write-ups with either group of people. No write-ups in either jail. Then, yesterday we got to hear someone who's actually putting these kind of ideas into practice. Director Fitzpatrick is in charge of classification. He told you his top priority is public safety. Safety of staff, safety of visitors, safety of inmates. 142,000 inmates plus in TDCJ right now. 30,000 employees. 29,000 approved visitors. If all of them were subject to violence, that wouldn't be true. We'd have 29,000 volunteers. Director Fitzpatrick told you he uses evidence-based practices to classify people to determine where to house them based on their needs, but number one, based on safety. Takes a holistic approach, looking at medical, looking at mental health, looking at history, criminology, trying to rehabilitate if there's drug issues, trying to do vocational training, do education, all those things that would hold you back and might bring you back to prison. Let 50,000 out, 56,000 in. He's thinking about that all the time. Individual treatment plans for rehabilitation. Complete medical and mental health workups before they do the classifications to know what they need, where they're going to need to be housed. 34 facilities that all have different ways to house somebody. There's a classification profile for each inmate that's constantly updated. Incentive program to try to make like parole is the only incentive. It's not. Where you're housed, whether you can work, freedom to move about. Those are all incentives. Remember, I told you, yes, this is a society, but it's not our society. This society has 24/7 security. It has trained staff. It has appropriate screening for the visitors. I don't make it sound like they're walking around there. No, mass movement is when group of people have a place to be, and they have to be moving to where they're supposed to be. Otherwise, individually, you have to have that path and be going where you're supposed to be going. It's not a free-for-all. And ultimately, their expert said they have a reasonable and effective way to house someone who's been sentenced to life without parole while ensuring the safety of the public, the staff, those visitors, and the inmates. Did have one point of contention. Tanner Strand testified. And I will tell you, I've had a lot of cases where someone was supposed to testify that was in the jail with my client. It's the first time it's ever happened. I'm glad it did. I found him interesting. But he disagreed with Director Fitzpatrick that there are predators and prey in prison. He said there are wolves and sheep. And to his face, he kind of had...
I'm sorry. Did he just say that he disagreed, that the witness disagreed that there were predators and prey inside of a prison, that he classified them as wolves and sheep? I'm sorry, chat. What is a wolf to a sheep? What is a sheep to a wolf? Are you kidding me right now? Is this really what you're trying to? Are you intentionally insulting the jury's intelligence, or is this on an accident? Because I can't.
I am so tired of you.
Like, I thought my biggest issue was going to be Miss Anderson over there. But Mr. Goebel said, hell no, hold my beer, here I come. Golly.
to describe his friend Tanner as an itty-bitty little baby lamb. He's trying to prepare him for what he's moving into, but you've heard what a struggle that is. And finally, you don't have to believe any of these. You've seen it with your own eyes. The state played all these videos for you. You've seen what Tanner's like around authority figures, around security. You can see how threatening they thought he was. The arrest video, completely compliant, no resistance, does exactly what they tell him. He asked about maybe moving his cuffs because they were uncomfortable. They just took his cuffs off. Don't worry about him. Standing there drawing on the board, they're standing right next to him. I don't even do that always with all of my clients because you never know. I have some that are dangerous. Tanner's not. They stood right beside him. Nobody was worried. They drove him around looking for Athena. No incidents. They put him in the front seat. Stood outside chatting with him about Waffle House, smoking a cigarette. Nobody's worried. And while tried to give you evidence, the state played those videos for you. Ultimately, the burden's on them. They have to prove beyond a reasonable doubt that Tanner Horner is going to be a continuing threat to society in a prison setting with this classification, G3, with their constant workups, with the many housing options they have, that he's going to be a continuing threat to society, and he just isn't. So that's where we come back to that oath that you all took to follow the law. And this is the law. The law isn't that you get the death sentence because that capital murder was worse than another capital murder. They're all terrible. This one is terrible. But he will spend the rest of his life in prison for it.
Sanders.
Good morning. I'm here to talk to you about special issue number 2. I promise you I'm not going to sit up here and rehash the experts' testimony. You have the reports. You have their notes. You heard what they said from the witness stand. I'm also not going to stand up here and rehash all the evidence. You heard the evidence. And if you have questions about what the evidence showed, you have the absolute right to come, to knock on that door and ask the judge, hey, we have a question about that evidence. But when it comes to special issue number 2, we're talking about the mitigation aspect of it. And we only get to special issue number 2 if each and every one of you has decided that the state has proved their case beyond a reasonable doubt that Tanner Horner is a continuing threat to society. Only if all 12 of you agree will we even get to this part. But in order to understand this, in order to understand the importance of mitigation, especially in this case, you have to understand child development. Because understanding how a child develops is key to understanding the man Tanner is today, but also the person that was in that van on November 30th of 2022. Tanner's problems began before he was even born. And we know that child development begins in utero. So Tanner's mother drank alcohol heavily during that first 8-week period of her pregnancy. We also know that she smoked cigarettes. We also know that she smoked marijuana. And the result in this case was a diagnosis of fetal alcohol syndrome disorder. Now, FASD is a neurodevelopmental disorder that is characterized by emotional dysregulation, cognitive impairments, problem-solving abilities, and other issues. Now, how do we know that FASD is a valid diagnosis? It was supported by the testing. It was supported by imaging. You have the reports, you can read those. The fact that he was diagnosed with fetal alcohol syndrome disorder is uncontroverted. There are several phases to child development. We know that it begins in utero, but once you're born, you have to learn to explore your own world. Now, where does this happen? When a child is born, their parents are the world. From your parents, you learn love, you learn safety, you learn security. But what happens to a child that doesn't have all of those? Now, again, it's undisputed that his mother loved him very much. But did she have the ability to provide security? Did she have the ability to provide safety? She didn't. During this crucial part of his development, rather than providing him that security and safety, what did his mother do? Left a 10-month-old child, baby, with a 10-year-old cousin to babysit. Not just for a few hours, not just late into the evening, but overnight, and for multiple days at a time. Now, the babysitter, even at that young age, realized that something was just a little off with Tanner. He wasn't like the other kids. One minute he was running around like the Tasmanian devil, and at other times he would put himself in timeout and face the corner and be still. But the other thing she noticed is he liked to eat coins. She had to put them up on the shelf so he could not get to these coins. He loved to eat coins and then go to the bathroom, poop them out, and then try to fish them out and do it all over again. She had to hide the change because he was his own ATM machine. And that's important because, according to the experts, that was also indicative of ADHD. Also, during this critical time period of development, his mother was in and out of the picture all the time. We know that she had her own issues. We know that she was in and out of jail. We know that she was in and out of drug rehab facilities. But that impeded Tanner's ability to have attachments. And Dr. Brahms talked to you about the importance of having a parent with whom you can form attachments. She talked about how important it was to have a parent from whom you can learn your coping skills. She talked about the importance of having a parent who could help bond and shape their behaviors. We didn't have this with Tanner's mother. She's a brave woman in many respects. She was brave enough to recognize that she could not provide for her son in the way that she wanted to. She had the desire, she did not have the ability. So she did the most heartbreaking thing that I think a parent could ever do, and that is give up her son to her mother to raise. And that was a very brave thing to do because she knew that Tanner would be loved by the grandmother and would be safe while she went to go to rehab to get clean. She also knew that she had legal problems and spent a good time in jail as well. Socialization. It's the next phase of childhood development. Socialization occurs when children are learning, basically how to navigate in the world. And you look at it like when you're a baby and you're a child, again, your parents are your world. Your crib is your environment. You have the safety of the confines of your own home. And then you go to pre-K. And then you go to daycare. And your world changes. It's a whole new environment. You don't have that safety net of your mom sitting next to you. You don't have that safety net of your wubby around with you. You have new experiences, new people, new things coming at you from all over the place. And if you are not equipped with the skills to navigate and to socialize, then that can impede your development. So we know that his grandmother had enrolled Tanner into daycare, Miss Diana's. And for the first time, Tanner had the opportunity to really socialize with children his own age outside of the home and outside of the family. But what happened at Miss Diana's? Well, Jackie watched as her only grandson tried to play with the other kids and was rejected. Tried to have conversations and was rebuffed. He tried to make friends, but he wasn't able to, and eventually he would just go sit on his own. That was when it was suggested that Tanner get tested. And what was the result? That was when the family learned that Tanner had Asperger's. Jackie and Melissa took their son to a clinic in Fort Worth. And it was there that they had the answer that they had been seeking. Why is my grandson different? Why is my son different? They knew he was different, but just looking at him, can you really tell? But they knew he was just a little off, so they took him in. Now, Asperger's is another neurodevelopmental disorder that's characterized by communication issues and social interaction difficulties. Now, all of those you could see at Miss Diana's when he tried to play with the kids. Now, Asperger's is not curable. Once you have Asperger's, you will always have Asperger's. You may learn some coping skills and some techniques to control the symptoms. You might learn how to have good eye contact. You might learn how to engage. You might learn how to do other things to help mask your symptoms. But at the end of the day, you still have Asperger's. And now Asperger's today falls under the autism spectrum disorder. So based on this diagnosis of the Asperger's, of the ASD, Tanner received special services in school. And you met the school psychologist who confirmed the diagnosis. You met the fifth grade teacher who talked about the difficulties that Tanner was having in school. And you also met the speech pathologist who helped him. The next phase of development is what was described as the mastery of one's own environment. Now, mastery of your environment is the capacity to effectively manage and manage our lives. And it teaches us how to manage our surroundings. That's when we learn. But it's difficult to manage your life and manage your surroundings when you have no stability in the home. And again, it goes back to the fact that Melissa was in and out of the house. Melissa had and had not custody of Tanner. He bounced between schools. He bounced between homes. He bounced between caregivers. He even bounced between rehab facilities with his mother. That is not stability. He moved out of the safety and security of his grandmother's home into a drug rehab facility. And where was his dad during all of this? Well, we knew that his father had legal problems. We knew that his father was an addict. We knew that his father was in and out of his life as much as his mother was, if not more. But during this phase of development, that was when one of the worst things that had happened to Tanner occurred. When he was 10 years old, he and his mother were living on a farm, and he and his cousin set fire. They were playing, and this fire got out of control. Well, his mother did the right thing, sent him down to the landlord to apologize for what had happened. So rather than accepting the apology and saying, no harm, no foul, I'm so glad you did this, thank you for apologizing, what did the landlord do? He anally raped Tanner. All because he accidentally set fire to a field. And we know that the records reflect that he had issues in school during that time period. The medical records reflect that he had issues with hemorrhoids and constipation. All of those are indicative of that type of trauma. We also know that he had difficulty admitting that and talking about it to the experts that were involved in this case. And that's not uncommon either. So after having suffered that trauma, Tanner transitioned into middle school, where he was still receiving services. Now again, you met with or you heard from the in-home facilitator who tried to teach him social skills. And he was responding, did a great job. She loved hanging out with him, loved taking him out into the community, loved watching him develop. But she also talked to you about how difficult it was at home because, as much as Jackie loved him, she just wasn't getting it. As much as Bill loved him, his grandfather, he just wasn't getting it. As much as his mother loved him, she still wasn't getting it. And she and Melissa and Bill, none of them were allowed to continue with, and none of them followed through with any of the lessons that the in-home facilitator taught. And she said, he still needs them. But the school decided they were going to discontinue the services. Now, during your adolescence, you learn from Dr. Brahms that identity begins to form. And we shape our own identities. Remember back in high school where you experimented with different friends, different cliques, different hairdos, different clothes styles, looking for who you are and trying to find who you are. This stage of development is especially difficult for one who has level 1 autism. Why is that? Because just looking at somebody, you can't tell if they're level 1 autistic. But the thing is, they know they're a little different. They know they're a little off. They know that they just don't quite fit in. They start to see themselves as an outcast. They start hanging out with other people that they identify with, other outcasts, and it becomes that self-fulfilling prophecy. When we talk about identity, we have to ask ourselves, what is it like to be Tanner Horn? And Tanner described himself as being an android when everybody else is an apple. And he feels like a robot, but that defaults to human emotions. And that's important because it shows that he recognizes that he's just a little different, but so wants to fit in. The other thing that Dr. Brahms talked about was how important it is to have someone in your life during this critical phase that can encourage you, that can recognize your successes, give you that positive feedback that you want and that you need. He didn't have any of this. Again, he had a mother who loved him, but she was struggling with her own issues, the legal problems, the drug addiction, her own personal trauma. He had a grandmother who loved him, but she was also struggling with her own personal traumas, the traumas that she herself suffered, the traumas that were inflicted upon her daughter that she harbored such guilt for. She also had her own physical health to contend with. The last phase of childhood development that we learned about was emancipation into adulthood. And that's where we talk about where we have developed coping skills to become the integrated adult that we are. Now, what do we mean by an integrated adult? Well, that means that be able to absorb what is around you and take that in and make your decisions based upon what you've learned. No one at home taught him how to do this. He had no coping skills. His default became avoidance. He avoided everything. He deflected to music, to anime, to movies. And he never learned to deal properly with the stressors in his life. So we talked about interventions. And it's no doubt that Tanner had a lot of interventions. He had the speech pathologist during middle school. He had the content mastery teacher in high school. He had Beth. He had his fifth grade teacher helped him out. But remember what you learned is that if you don't continue with these interventions, use it or lose it. He didn't have anybody at home that could help him use it, and so you just kind of fall off. And it's also important to note that high school content mastery, it was available to everybody, and it really did work for him. It helped him graduate. Now, granted, he graduated in like the bottom 5% of his class, but he went on to graduate. After he graduated, things kind of drifted from band to band, from job to job, and then he met the mother of his child. They fell in love, moved in together, and they had a child. But moving in and having a fiance and having a baby isn't the same as settling down. Now, they moved around a lot. They still had a lot of chaos in their lives. They bounced between her mother's house, his grandmother's house. They lived with friends. They had their own apartment, all these different things. So there was still chaos in the life. They also had financial difficulties. We know that the mother of his child was suffering from postpartum issues. She wasn't able to work, wasn't able to keep the house, wasn't able to do all the things that she wanted to do, except go out and party. And we know that that's what they did, even though they were trying to save money to buy a place of their own. So Tanner was trying to be the only breadwinner, keep his fiance happy, save up to get the place of their own. They never could seem to get ahead. They always had these issues. And then the car that they had broke down, so they had to get a new car. Kept rolling and rolling and rolling, and his boss came in and gave him $1,100. But that also added another layer of stress, because now Tanner had to work 6 days a week in order to pay that $150 a week back. When he took the job at FedEx, he thought that that would give him some stability in life. That's what he was hoping. And for a while it did. They still had the money problems, and they were working through all of that. But he had the root nasal. That's where he grew up. He knew those streets. He was able to do his roots without issue. And then his route got changed. Added another layer of stress. Another layer of stress that he was not able to cope with. When the route changed, the anxiety increased. New routes, new roads, new people, new routine. And that's what led up to this offense. We don't forget Athena. We don't. Because on November the 30th, 2022, Tanner did something that changed the lives of all of us. Every single person in this room has been affected by Tanner's actions. On that day, Tanner delivered the packages to Athena's house, Barbie's. And he got out, delivered the package, decided to snort a little cocaine because he had had insomnia, was tired, had all these other issues. And she saw him, and he thought that she was going to tell on him. And if she told, he would lose his job. If he lost his job, he would lose his car. If he lost his car, he wouldn't be able to have transportation for the baby. If he didn't have transportation for the baby, something could happen. He couldn't do this. It just kept snowballing in his mind. Now, there was no planning. There was no premeditation. There was no preparation. You kept hearing about all of these stickies being put on the lens cover. But let me ask you this. If you were planning to abduct a child, would you cover the lens cap before you did it or after you did it? It doesn't make sense, and that's where their assertions fall apart. It does make sense that he would have covered a lens cap to hide the fact that he was vaping weed. It does make sense that he would hide the lens cap or cover the camera lens if he was snorting some cocaine. It does make sense that he would do all of that, but it doesn't make sense that he would wait until after she was in the van to cover the lens cap.
Because it was a crime of opportunity, you idiot. He had no idea the day that he rolled up to that home that they were going to cross paths. He saw an opportunity and he took it. He didn't have time to cover up the camera. The jury gets it. You're just insulting their intelligence at this point.
All of this was caught on video and audio. And like I said, there's not a person in this room that heard that was not deeply affected by that. We all were, and we all will have to carry that with us for the rest of our lives.
No one should have to go through what Maitland Gandy and Jacob Strand went through. No one should have to bury their child. And when a child is taken in the way that she was taken, it's natural for us to be angry. We should be angry. We should be furious that her life was taken from her in that manner. We have every right to be, and we should be. And it's natural for us to want to know why this happened. But you know what? We won't ever know why it happened. It's easy to sit here and blame the autism, the lead exposure, the FASD, the ADHD, the mental health issues. It would be easy for us to do that. And the state keeps telling me that that's exactly what we did. But remember, every single witness that we asked, is this an excuse? This isn't a defense. This isn't a justification. And every single one is like, no. The fact that he has autism is not an excuse for killing Athena. The fact that he has fetal alcohol syndrome disorder does not excuse the attempted sexual assault. The fact that he has lead exposure does not excuse the murder. It is no excuse. It is not a defense. It is not a justification. But what all of these diagnoses do is it kind of helps explain how we got to this point, how we got there.
Okay, so I want to just say, yes, Melissa, premeditation can happen in seconds under the legal definition. And I think what they're talking about here is less the legal definition of premeditation, but more planning. The fact of the matter is, the murder became premeditated when he put his hands around her neck. That's it. That's all it took. They became the weapon. He knew that squeezing her neck like that, constricting her airway, was likely to cause death. That's all the premeditation it needs. Was he planning to abduct and murder a little girl? That is what the defense attorney is saying is not what happened. But what the rest of the world knows is exactly what happened. He was always planning. That's what he was doing. He stalked that neighborhood like a predator, like a wolf would stalk a flock of sheep. That's what he did. Stop playing with these people, lady.
Now, the state wants you to believe that unless you're sitting in a corner drooling all over yourself, you are not impaired. But every single expert in the field said level 1 impairment is still impairment. Mild is still impairment. Moderate is still impairment. You just aren't a little pregnant. You either are or you're not. You are not a little autistic. You are or you aren't. You are not just a little alcohol exposed. You are or you aren't. There is no if you are, you are. So the important thing to remember about these diagnoses is that they are not what we call additive. It doesn't mean he has autism plus FASD plus lead exposure plus ADHD plus mental health. That's not how it works. All of the experts testified that this is a compounding issue. So it would be autism times FASD times ADHD times lead exposure times all the other mental health issues. And so it doesn't boil down to, well, you had a bad upbringing, you didn't kill anybody. Well, did that person also have autism? Did they also have FASD? Did they also have ADHD? Did they also have lead exposure? So we have these false equivalents going on throughout the state's questioning. It isn't a false equivalent. It is a compounding issue. So, again, what does it all mean? We know that Tanner had a history of catastrophizing. We know that. And in the most simplistic terms, it's making a mountain out of a molehill. And when he thought that Athena saw him doing cocaine, it never dawned on him that she wouldn't know what it meant. It never dawned on him that she might not recognize that what he was doing was wrong. In his mind, he jumped from point A to point Z in the most irrational fashion. So somehow, somebody, a child seeing him do something that they may or may not understand, ended up in him losing his child, losing his car, and being evicted from his house. So that's how his brain worked. And once he made the decision, the very bad decision, to take her, it just snowballed out of there. He didn't know how to get out of it. He wasn't able to reason and think about the consequences of his actions. And again, that's not anything new, because you heard from the teachers who recognized that issue all the way back in 5th grade. So this isn't something that the defense cooked up to try to get him out of it. No, we have the documentation from it. And you have those records. You can look at those records. You can take every single bit of evidence back there and go through it. You have that right. Just ask the judge to send it back with you. The catastrophizing isn't new either. You saw that also through many stories that you heard from the witness stand, especially the one where, they talked about him losing his patience over at Outback over the dishes piling up. He was overwhelmed and wasn't able to cope. So rather than asking for help, which we kind of would probably think the normal person would do, no. He became overwhelmed and he quit because he couldn't handle it. And we talk about these diagnoses and how they are presented. Well, they were on full display during the interrogation videos. Full display. Dr. Brahms told you that every 5th sentence in those interrogation videos were diagnostic for her. Now, we know that he lied. We do. But as Steve pointed out, lying goes back to the dawn of time when we've tried to cover something that we have done wrong. It's not anything new. Officer Amy lied to cover her tracks. Joe Espinoza lied to try to get a confession. We have, to say that because he lied about the multiple personality disorder should discount everything else we know in this case is just a bunch of hooey. What we have to ask the question we have to ask ourselves is, was this lying a manipulation, or was it just a way of enabling himself to confess? Did Tanner actually confess? Yes, he did. But he did it in a different way. He took on the persona of Zero to enable him to make that confession. And we know that it's not uncommon for people with autism to speak about their person, speak about their brains in the third person, because it makes them easier to talk about their issues. It makes it easier for them to admit to things that they're embarrassed about, that they're ashamed of, that they're afraid of. But at the end of the day, was there a confession? And I got to ask you this, and we asked one of the witnesses, I can't remember which one, but we asked, did Tanner really think that he was fooling anybody by adopting that persona? I mean, Ranger Espinoza wasn't buying it. I don't think any of us was buying it. But, due to Tanner's lack of theory of mind, he was not able to perceive that the other people were not buying what he was trying to sell. And again, at the end of the day, he confessed to the crime and eventually led the officers to Athena's body.
No, ma'am, Pam. He did not confess to all of the crimes. He confessed to the murder. That's what he confessed to. He didn't confess to the entire crime. Stop playing with these people, lady.
You have 5 minutes.
Thank you. Now, during jury selection, we talked about what was important for you to hear in order to make your decision. And we heard responsibility, remorse, rehabilitation. Well, responsibility, Tanner confessed. He confessed to the offense. Responsibility, he stood in front of you and entered a plea of guilty. He entered a plea of guilty knowing that the result would be he would spend the rest of his life in prison. Remorse. Now, I remember when my mother passed away. I was angry at everything. I was angry at the world, angry at God, angry at my family, because I didn't think that they were grieving the way that I thought they should grieve. So I went to church and I spoke with my priest and we did a little grief counseling, and what he taught me was that everybody grieves their own way. And it's right. If it's right how you grieve, it is right. It's the same thing with remorse. If we all show remorse differently. We do. And just because it's not shown in a way that you want it to be shown doesn't mean that it doesn't exist. And let me ask this question. How does a person with autism, where one of the characteristics is they are not able to express their emotions, how do they effectively communicate what those emotions are in a way that is satisfactory to the world around him? Well, you saw the remorse in Tanner. You saw it on the interrogation videos. Even Ranger Espinosa noted that, I see the remorse in you. I believe you're remorseful. You saw it in the suicide note that he wrote when he had nothing left to lose. And he had nothing left to gain at the time. He apologized to the family for what he did.
Sorry, you guys. I meant to click pause and I accidentally closed it. I'll fix it. I'm sorry. He had nothing left to lose. He had nothing left to gain. So then why did he lie? That's a problem. I mean, do you not see that problem, lady? Hold on. I'll get us back to where we were. All right, here we are. Got it. Hold on, let me make sure. All right, just want to check. Okay, sorry about that, you guys. My bad. Here we go, right back into it, right where we left off.
And he had nothing left to gain at the time. He apologized to the family for what he did and expressed his regret and remorse. You saw it in his face when the video of the incident was replayed. Again, just because he may not express it the way everybody else does not mean that his remorse is not there. Rehabilitation. You heard about what he did in jail. You did. You heard about all of the courses that he took. You learned about the fact that he found God again and that he wanted to help his other inmates find God. And that was his new purpose. He reached out to Chicken and they started a Bible study. Even though they had to talk through the bean chute, even though they couldn't share their own Bibles with each other, they had that Bible study and it was important to him. The note that Chicken wrote him is in evidence. I encourage you to take it back and read it, because that was written by a man who wanted to express his gratitude for helping him find God again. The things that in life that created deficits for Tanner in the real world are the things that are going to serve him best in prison. Structure, clearly stated rules. And we know that structure worked for him because it worked for him in school. You heard that from the teachers. It worked for him when he worked for Jason. You heard that from Jason. It worked for him in Wise County where he had no disciplinary actions. It worked for him in Tarrant County where he had no disciplinary actions.
Okay, so she's going to talk about structure, right? And there's, how it worked for him in Tarrant County, how it worked for him in Wise County. In Wise County and Tarrant County, he is housed in a single cell unit. It's just him, the sink, and the toilet, and the bed. That's it. That's all. Guess what else is like that? Death row. So clearly, that's the type of environment he functions best in. If he were to be in general population, that is not the type of environment he would be in. He might have a cellmate. He would be in a dorm, like with pods, so be able to come and go. Clearly, he doesn't thrive in a chaotic environment. Send his ass to death row. It's not chaotic there.
Only time when he didn't have the structure in his life, he flailed and he failed, and that's why he's sitting in the defense chair right now. The decision to end another human's life is a deeply personal one. And each of you was selected to be on this jury because, you promised us that you would follow the law. You promised us, you promised the judge, you promised the state, you promised us that you would follow the law regardless of where the evidence took you, regardless of your personal feelings. You promised you would listen to all the evidence and you would hold the state to the burden of proof. But now's the time for you to fulfill the oath that you took. And the state of Texas never requires a death sentence. Not in this case, not in any case, not even in the worst case you can possibly imagine. They're always satisfied with a verdict of life without parole. And you are going to be tasked with answering special issue number 1 and special issue number 2. Did the state prove beyond a reasonable doubt that Tanner Horner is a continuing threat to society? No, they didn't. In fact, evidence to the contrary, it's uncontroverted that he has adjusted well to jail life. It is uncontroverted that he has no disciplinary actions. It is uncontroverted that he has been allowed to have access to all of these people in the jail without incident. But if you answer yes, that only makes him eligible for the death penalty. It doesn't mean it is automatic. And that's where we get to special issue number 2. Mitigation is any reason for any one of you to choose life. And it can be individual for each of you. That's why we talked about your individual moral judgment during jury selection. You have the absolute right to pick and choose what is or is not mitigating to you. And if you have found something that is sufficiently mitigating that would warrant a sentence of life without parole rather than the death sentence, you have the absolute right to vote your conscience. You have the absolute right to have your voice heard. So when you go back in that jury room, what I want you to do is I want you to talk to each other. And y'all have been talking for like the last 5 weeks, and what's a little more talk, right? I want you to talk to each other about your lives, about your experiences, about the things that make you who you are. Talk about what you saw. Talk about your children. And then what I want you to do is speak up. I want you to speak up. If you have a reason to choose life, speak up. Because that is your right. Your truth is your truth, just like your other jurors' truths are their own truths. Honestly, I don't envy you. I can't imagine being in your position and having to make this decision that you're about to make. It's probably going to be one of the most important decisions you will ever make in your life because you hold a man's life in your hands. And your decision, it'll define who you are. And are you going to be merciful? Are you going to be benevolent? Are you going to be vengeful? Because mercy isn't earned. Mercy is freely given. That's why we call it mercy. Then ask yourself, do you really stand for life? And if you can answer that question, then I want you to raise your hand, and I want you to vote your conscience, and I want you to vote for life. And that's why we are asking you to sentence Tanner to life without the possibility of parole. Thank you.
Mr. Staton.
Thank you, Your Honor. You know what else you hold in your hands? Justice. That's what you hold in your hands. And I want you to ask, was Tanner merciful? Was Tanner vengeful? Did Tanner show remorse? Nope. And I think that's important. Talked a little bit about adjusting to jail. You know what? I fully expect somebody who's staring down the barrel of you sitting here as a jury would probably act right while they're in jail. Well, how did he act when he didn't have that? How did he act when he didn't have that incentive? It's right here. It's right there. That's how he acted when he didn't have that. So, when you want to say he's rehabilitated, he hadn't had access to anybody else. And I believe giving him access to anyone else in life in prison is a mistake. He should never have access to hurt anyone again. Ever. Now, we talked about whether or not Tanner showed remorse, and I don't really know why we need a psychologist and a bunch of excuses to explain to us how someone shows remorse. I mean, was remorse to lie? You want to use the suicide note? Well, it said, yeah, I'm sorry, but. It said, well, I'm going to throw out a whole new theory out there for the family to cause them more pain. Make up another story that they're going to have to deal with. That somehow remorse? I don't even know what the word that lady used. I can't even spell it. But if you got to have a degree in psychiatry and psychology and use a 12-letter word with an X in it, I really don't think you're really remorseful. You know, I dug through some stuff. That's a bunch of reports, notes, everything that came right over here. Everybody, how many 100 hours? 100 hours or more? How many psychologists, how many experts? You know what you won't find in this box right here? I'm sorry. Not a single time in this entire box. Now, what this entire box is full of, it's all about Tanner. He's more than happy to talk about his life, more than happy to talk about his problems. He's more than happy to talk about that. But you would think, in 100 hours, you would think all those experts, somewhere, someplace, one single time, stop what you're doing, quit talking about me, and just say, I'm sorry. I don't think that's too much to ask. But you can dig. It ain't in there. Now, Vince wants you to give him credit, if you will, for coming in here and pleading guilty. I think it's bigger than that. I think if people are truly remorseful and people truly take responsibility for their actions, truly, then those are those people that we should talk to about that. But that's not what we have here. Not in any form or fashion. We have an individual that continued to lie and make up stories all the way through January of 26. That is not someone who's taking responsibility for their actions. That is somebody who continues to lie, divert, and is attempting to continue to change the narrative about themselves. Now, this whole catastrophe theory. You know, if you really believe that a 7-year-old girl knows what it looks like for somebody to be doing blow on the hood of their FedEx truck, that's crazy. The simple truth is that's another lie like anything else. And you know how I know it's a lie? Because once you find out that we've got you dead to rights, you make up another story that fits your narrative. This fits his narrative. Just like everything else, just like every other lie. But you know what the problem is? What the problem with this whole catastrophe theory is, the expert up there, Dr. Ryan, this Anderson just did the same thing. He said you went from A to Z. Wait a minute. Did he go from A to Z? No. He didn't. He said, you're pretty. Take off your shirt. Take off your clothes. That's not A to Z. Stopping off in the middle to sexually gratify yourself on the child you just kidnapped. That's not catastrophe. That is a true predator. Someone who stripped a child away from their home, took pleasure in sexually assaulting them, and killed her. That is not catastrophe. Because that's the whole thing. That's why every expert up here ignored that one part. That's why Miss Anderson ignored that one part. Because you can't explain it with catastrophe theory. You just stopped off in the middle of your catastrophe and did this. That's not what we're talking about here. That is true evil, is what that is. Now, you know, we talk about these interrogations. I don't know how much nicer that Ranger Espinoza could have been. I don't know how much more friendly he could have been. And I don't know why we continue to try to excuse Mr. Horner's conduct. Clearly, he thought he could come in there and make some kind of deal. But let's look at the bigger picture here. Let's look at all of this. What is this? It's selfishness. It's internal selfishness. It's nothing to do with her. Nothing to do with her. It's all about him. It's everything that's in that box. It's all about him. That is selfishness, is what that is. Is that he is coming there and he is saying, hey, I'll tell you what you want, but you got to give something to me. And I want something. I want to see my kid. Where did Athena spend Christmas? Did she get to have videos with Christmas that year? Nope. Now, we keep talking about excuse, and we keep hearing people tell me it's not an excuse, but I hear all of this stuff that's going on led up to this offense. All of this stuff that's going on supposedly in his mind led up to this catastrophe. All of this stuff that's going on because he had stress from work. He had a change in routes. All of this stuff led to something else. That's simply saying, yeah, I did it, but, and that's the key. I did this, but hey, look at this. That is the definition of somebody trying to excuse their conduct. And I'll be honest with you. One of the things that really got me fired up in this case was there are thousands of people in the world We know them. They're sometimes our friends, our family. Thousands of people in the world that have disabilities. Thousands of people in the world that are autistic. And they get up every day. They live their life. They work. They have families. They struggle. They succeed. And they fail. But the one thing they never do is use it as a crutch.
Your Honor, we would object. The state is trying to create a nexus between the mitigation and the offense, which is not allowed.
Overruled. How much longer do we have a juror that needs to take a break? How much longer do you anticipate Pete? Not trying to cut you off.
How much longer do I have?
You've got about 25 more minutes.
I got you. I got you. Let me end with this. We talked about two things, future danger. Every single expert that got up here, every single one, told you they would have never predicted this. They would have never predicted he would have hurt this little child. They would have never predicted that he would have sexually assaulted her. They would have never predicted this whatsoever. They were wrong. Absolutely wrong, and every one of them admitted it, that they were wrong. So anybody who comes up here and tells you today that they can somehow predict the lethality of this man at a later date is wrong. Here's what we know. We know he has a capacity for maximum violence. He has a capacity for victimization. He has a propensity for sexual assault. Now, all of those we know. I don't need an expert to tell me that. I can look at the autopsy report. I can look at the pictures. So when you talk about future danger, look at the fact. Look at what he's capable of. Look at what he's done. And don't think that there's not some other victim out there waiting. Don't think that. If you think, this is the way I think about this. If you put a man-eating tiger in a cage, he doesn't somehow become a vegetarian. And that's exactly what we have here. Just because you cage this lethality doesn't mean it goes away. But hey, we wouldn't have predicted this. We wouldn't have predicted this. But you can trust us now. He won't do it again. I submit to you that the only option here is to prevent him from doing that. Don't give him access to anyone else. Now, mitigation. There is nothing I can tell you.
Hang on, Mr. Staley. Juror has to take a break. Go ahead. No, come on, everybody's got to go.
Just really quickly, that was the perfect analogy. That was the perfect analogy, and he connected with those jurors. All right, let's hear what the rest of it. And just really quickly, in case you're listening and not watching, I have added to the description of this video the nonprofit in Athena Strand's name that her mother, Maitland, started for her. Take a moment, check it out. Give if you feel like it's like you can't. Give if you can. And I mean, I looked over the website, and they do really amazing things. One of the things that they have done is donated custom caskets for children lost in the Camp Mystic flooding tragedy, and one additional child lost in an unrelated vehicular accident. This is what they've done in 2025. Direct financial support for 2 families who have lost children to vehicular accidents. They break it down. They talk about the Athena alert. When I get, I'm going to see if I can nominate this nonprofit, because it is a registered nonprofit. I'm going to see if I can get it I'm going to nominate it to be part of YouTube's giving program, so that I can do a fundraiser, and it will go, I will have nothing to do with any of the money. It will go directly to the Athena Strand Foundation. So I'm going to nominate that for to be part of the YouTube giving. All right. That's all I wanted to say. Okay, we'll get back to it now.
All right, everyone may be seated. Mr. Staton, you may continue.
Judge, appreciate the break. I think we all appreciate the break, Judge. I don't have much more, ladies and gentlemen, jury. When we stopped, I was talking about mitigation. In mitigation, we talk about the definition of something that reduces someone's moral blameworthiness. I don't know how there's anything possible in this case that reduces the moral blameworthiness of taking an innocent child, gratifying yourself on an innocent child, and then committing the kind of brutal murder that one committed. I can't see how there's anything that mitigates that reduces anybody's moral blameworthiness. But this is what we get in capital murder cases. We get a capital murder diversion, is what I call it. It's basically you got somebody living their life, doing what they're doing, working, got a family, doing their best, succeeding, failing, buying a car, doing all those things, not being treated really for anything in their life, just working and doing what they're doing. But all of a sudden, they commit a horrific act. And the experts come out in droves to start explaining every single ailment that they possibly could have. And that's what happens in these cases. Nothing was going on in your life that caused you to have any issues before. You had a job. You were doing things normally. You were making some poor decisions. I mean, I submit to you that anything bad that is happening to Tanner Horn at that time is by his own doing. You're not going to keep a job if you're out doing coke on the weekends and partying. You're not going to keep a job if you stay up all night and play video games. You're not going to keep a job or a relationship if you're doing acid on a regular basis. These are all things that are somebody's choices. They don't have anything to do with any disabilities or deficits that you have. So I think that to come here and to say, hey, now I wouldn't really have any problems before, but now I want everybody to look at this. I don't think that makes sense. So remember what every single expert said, and we did ask him the same thing. One, did he know what he was doing? And every expert, including Dr. Brahms, the last expert we had up here, I asked her, did he know what he was doing when he kidnapped her? She wouldn't give me that when she subscribed to this catastrophe theory. But when it came to the sexual assault, she said, yeah, he knew absolutely what he was doing to her when he was doing it. And then when I asked her about killing her, he absolutely knew that what he was doing was going to cause her harm. Those are her words. That was the first question. And the second question we always ask is, did any of these conditions, any of these things, this litany of things that are out there, true or false, did they have anything to do with this? No. And that's what it comes back to. For all intents and purposes, Tanner Horner was driving a FedEx truck. And I believe he fantasized about this. I believe this was something he had in his mind.
Counsel's opinions are not relevant.
Just stay within the record.
The experts told you that he fantasized about things. He fantasized about what he wanted to be. He fantasized about being superhero. I think it's reasonable to believe that he planned this as well. This was something that was in his mind.
Objection, Your Honor.
Overruled.
Counsel's opinion is not relevant.
Overruled. Like Dr. Randall has said, these things don't just spontaneously occur. And now you've heard some evidence of that. You heard some evidence of things that happened in the past, where he had done things in the past to victimize people. It never came out. You heard Billy come up here and struggle to talk about that. I think that's important, that he was able to come up here and tell you what happened to him. I think the two victims that came up here that were assaulted by Tanner Horner took a lot of bravery to come up here and talk to you about that. I think that that's important. So all of that goes to say that there's no doubt that this was coming. We were just waiting on it. So when we talk about going to prison and serving life without parole, all we're doing is waiting on it to happen again. That's all we're doing. And now all the Tanner's victims are in the same cage with him. Now we didn't have to go find them. So I submit to you that the only proper verdict is one that prevents him from doing that. Now, we talk about structure and consistency. We talk about sameness. We talk about lack of change. Yeah, the Polunsky unit in Livingston, Texas, has all of that. And what else it has is protection. It's protection for every single person who he might victimize in the future. That's the right place. That's the place where he needs to be. That's the place where there's consistency. That's the place where there's structure. That's the place where there's sameness and routine. Now, because of his actions, because of what he did, Athena, he has forfeited his right to sit around for the rest of his days, watch TV, play video games, hang out, go outside, see the sun on his face, have a job, walk around the prison like everybody else. He has forfeited that right here, because of his own actions. Not because of anything else, but because of what he did. What I'm going to end with here is this. Everybody's got things, two things actually. Everybody, we all have things that are mitigating in our life. The difference between us and him is we don't use that as an excuse. Now, the depth of what he caused, the level of evil, the level of pure blackness in one's heart. It's not only just Athena, it's her family, it's the community, it's all of us. And I think that we've all lived through this. And I want to tell you just a short story about the level of pain, about the level of trauma that this has caused this family. A lot of you guys, I'm here, I'm the DA, you probably think I meet with people, I have to give them bad news sometimes, and I do. That's part of my job. But not like this. The story I'm going to tell you is the story of when I had to sit down with this family and I had to detail to them what exactly happened in this case. I had to sit down with them.
Your Honor, objection. This is outside the record.
Stay within the record.
So whenever you have these cases, families are very involved. Been here at all the court dates. You guys can see that. It's important that we consider all of this when we make our verdict. And the level of pain, the level of abuse that he has inflicted upon this little girl and this family are unfathomable. The level of lies, the multiple different versions of whatever truth it is, that video, Everything you saw, it's important. Athena is important. Justice for her is important. And justice in this case has one result. I want to thank all of you for being here. Been away from your families, being away from your work. I appreciate your effort in this case. It's been a long month. And I'm going to await your verdict. Thank you.
Up until this point, you have been unable to discuss this case amongst yourselves because the evidence had not been concluded. But that restriction is now lifted. Retired to your jury and begin your deliberations. If you need me, write me a note. I'll be right out here. All right? All right? Yours and all. All right, we'll be in recess. Thank you.
All right, so that's that. They're in recess. It's important to remember when we're taking into account how long the jury might deliberate. I don't think this is going to take very long either. But I will say, hold on a second, I have to cough and I don't want to cough in y'all's ear. Okay. I will say that they typically have the jury's lunch delivered at 12:30 and they give them an hour for lunch. So presumably, that's what'll happen today. I feel like they're going to go back and talk for a little bit. Their lunch will be delivered in about 20 minutes and they'll have their lunch and they'll continue to deliberate. I think that we should have a decision by today for sure. It'll probably be after lunch. So this is what I'm going to do. I pinned the link to the verdict watch stream. That is where the verdict will be read live. We'll watch the verdict live. I think that, so just turn on your notification. As soon as this live ends, just go over there and it's right on my page under upcoming lives and select notify me. And as soon as the verdict is read or they announce that their verdict has been reached, I will go live. What I like to do personally is I go to Court TV because what I do is I can watch the clock and once the verdict clock stops, if it's any time before 5 o'clock, then and Court TV is really good about announcing verdicts. I'll switch back and forth between the live feed on Fox 4 and also WFAA is another good source. But don't worry, you guys. I'm going to keep both my eyes on this case so that we don't miss the live verdict. Okay. Jenny said, will they have victim impact statements today? Do you know? I don't think it'll, if the verdict is reached today, then if they are going to do verdict or victim impact statements, then it would be at the same time. So yeah, but I'm trying to think about if they do I'm trying to remember the last trial that I watched in Texas where the death penalty was on the table. I've never dealt with a trial like this one where the defendant pleaded guilty before the trial, and then the jury really had to only deliberate on the sentencing part. I think the last one I covered was the Border Patrol agent, and there were victim impact statements, but that was also because, but I'm trying to remember if that was even a death penalty. Yeah, that was a death penalty case. But I don't, but he didn't get sentenced to the death penalty, I don't think. I'll have to look it up. But anyway, yeah, I would I have a live stream scheduled for the verdict, so we'll find out what's going to happen. I don't know. The answer is I don't know. Hannah said Texas is unanimous for death penalty. I believe Florida is 10 out of 12 have to agree. Yes. The verdict must be unanimous for Tanner Horner to receive the death penalty. It must be unanimous. If it is not unanimous, then they tell the judge. See, if it is not unanimous, the judge gave the directions, and I'm sorry, you guys. It's because I'm not feeling good. I'm still not feeling good. And I think if they have, I can't remember, and I don't want to tell you guys wrong, but definitely I don't know what happens if it's not unanimous. If it's not unanimous, and I think there's and it's then it's going to be life without the possibility of parole. But anyway, yes, they have to be unanimous to find. Yeah, it has to be. Actually, as of 2023, it only has to be 8 to 12 in Florida, which is mind-blowing to me. They changed it in Florida, and I remember when this happened. They changed it because getting 12 people to agree on anything is difficult. And the state felt like 8 is enough. 8 is more than half. And that's what they agreed on. So that's why they changed it. They felt like requiring it to be unanimous was too high of a bar, I think. And they decided 8 to 12 is enough. Allison said it honestly shouldn't take long. I don't think that it will. I think that while deciding that somebody should receive the death penalty is a very, very heavy burden, the evidence is clear. There are no mitigating factors. And so by that definition alone, or mitigating circumstances, I should say. So based on that definition alone, it shouldn't take long, but that doesn't mean it won't take. I think it's going to take the average time, to be quite frankly. I do. Amber said, yeah, I get that. I just feel like it should be undeniable when you're dealing with someone's life. Just my 2 cents. Hold on, I got to cough again. I was surprised that it happened, frankly. But I mean, Florida, I lived in Florida for a long time, um, almost 10 years. And, the last case that I followed and reported on out of Florida was Stephen Stearns. Obviously, Boone, I still keep on top of because I covered that case from the very beginning to the end, which I followed it and then forgot about it. And then Dr. B, when we used to do true crime roasts, when we would roast interrogation videos, she was like, "Oh my God, what about Sarah Boone?" And I could not, for what I remembered the crime, but I couldn't place her name. And from that point on, everything that had anything to do with Sarah Boone, aside with her criminal case, I didn't get into her custody case or alimony case or anything like that. I didn't get into any of that, but I will tell you, if you enjoy like jail call roasting, Hear Me Out's channel, and it's just type in here Hear, and then Me Out is MEOWT. That's his channel name. He is hilarious. He really is. He does a really good job of covering her jail calls. But yeah, but Stephen Stearns, when the judge allowed Stephen Stearns to plead no contest to both crimes, to both the CSAM and the murder of Madeline Soto, that one did take me by surprise. I thought that the judge would require him to plead guilty. I really did. I didn't think that the judge would accept a no contest plea. But I also understood that that case, like this case, had a great deal of photographic and video evidence that the jury would have to view. And I felt like the judge in that case felt that it would be in the public's best interest and the victim's best interest to not quibble over the language that he pled in, whether it be guilty or no contest. So I was, I think it was for the best. Melissa says, I was shocked Mr. J even offered that. Well, in that situation, I think Mr. J was amenable to it because, like I said, I think that Stephen Stearns is a monster. What he did was monstrous. And I think that Mr. J felt that it was for the best to be done with him, that he should go as quickly as possible to his forever home in prison. And I think that, if Stephen Stearns, if he had said, well, no, he's got to plead, he's got to say the words guilty or the deal is off the table, he would have then had to put. See, the thing about Madeline Soto's case, the first case, because that was the one that was going to go first, was the sex abuse charges, but also the CSAM charges as well. And Stephen Stearns took those videos for a reason. He took those pictures for a reason, and they would have had to been displayed. And Stephen Stearns would have been able to see them. And I think that he likely felt like, this is how I would feel if I were the prosecutor. I wouldn't want Stephen Stearns to ever be able to relive those. I wouldn't want to contribute to Stephen Stearns being able to relive those moments with her. And I think I think Stephen Stearns would have, if those videos and those photographs would have been displayed. I wish that I know that that Miss Anderson referenced Tanner Horner's face when he was when the video of Athena Strand's assault and murder was played for the jury. She referenced that he had some kind of look on his face. She didn't actually say what the look was. She just said the look on his face. I thought that was odd, like not to. I mean, maybe she's not allowed to. I mean, I don't know. Maybe she thought it would be objected to. I am curious because I think that's, I don't remember. I don't remember Rebecca Lopez or the Carrie Bennett Hill, I think was her name, the attorney that was with her. I don't recall them actually talking about Tanner Horner's reaction. I remember them talking about everybody else's reaction, but not his. Look how Amber says, look how Tanner reacted when he just saw a normal photo of Athena, right? I mean, yeah. That's right. Rebecca said he looked down 3 inches from the table. So then what was the look on his face? Like, I don't get it. He hung his head down. I don't know. I think that's what I was going to say. Amber, get out of my head. And Amber said, in my opinion, he was visualizing the audio in his mind. Exactly. That's what I think. I don't think that was a sign of remorse, of guilt, like of feeling guilt. I don't think that Tanner is capable of that. And I don't think that it has anything to do with whether or not he's on the spectrum, whether or not he has fetal alcohol spectrum disorder, right? I don't think that that's why. I think that he is a monster. I think that I think that he has I think he has antisocial personality disorder. I think that what limited and what hindered the state's expert from truly diagnosing him with that is because of the diagnosing guidelines. I think that there was just not enough evidence, documentation, I should say. It's not that there wasn't evidence. I don't think there was enough documentation in the records to support that. I do think that the school counselor, no, not the school counselor, the school's language and speech pathologist that wrote in her report that Tanner lacked empathy, I think she wrote exactly what she meant. There's a difference between being able to show empathy in the traditional way we think of, right? And having difficulty with that versus a lack of empathy. That means something. That's very different. Those two are not interchangeable. And I believe fervently, hold on, I got a cough again, sorry. I think that she meant what she wrote, that he lacked empathy. I think that because they were in the, it isn't like Tanner was taken by his grandmother or his mother to be evaluated. The school was doing it. And I think that the school was what their goal was to address his learning, his behavior in school primarily, so that he could learn and he wouldn't be disruptive to other children, to their learning process. I think if Tanner had been evaluated in a different setting under other circumstances, like independently, I think there would have been documentation of an antisocial personality disorder. I think that Amber says, I think he's capable of feelings. I just don't think he cares about this. He's not sorry. That's the thing about psychopaths and sociopaths. It's not that they are not capable of feelings. They're capable of having feelings. They just don't care about other people's feelings. Other people's feelings are irrelevant to them. Tanner Horner, in my opinion, does not give a rat's fat kneecap about Athena's feelings. He doesn't give a rat's fat kneecap about Athena's mom's feelings, her father's feelings, anybody in her family. He does not care about their feelings. That suicide note or letter was self-serving bullshit, in my opinion. If he had nothing to lose and nothing to gain, then why did he continue to lie in those letters? I think that the death penalty exists for crimes like this. It exists for people, monsters like Tanner Horner. That is what I think. So, anyway, I just wanted, hey, Sharp family, good to see you. All right, you guys, I'm going to let you go. Like I said, I'll be watching for the verdict. Make sure you guys turn your notifications on on the verdict watch stream. Let's get justice for Athena. Quote, Amber wrote, quote, I'm sorry I killed your daughter, but it was FedEx's fault. Make sure you get a big pound. Exactly. That really was as if him helping, and I'm using air quotes, helping in the case against FedEx in the civil suit, right? Somehow makes amends, is an attempt at making amends for what happened, for what he did. Also, speaking of, before I let you go, I have one last thing. Two things. One, can we put pink hearts, mermaids, and unicorns in the chat for Athena? Justice is coming, babe. We're almost there. It's coming, Athena. It's coming. Do you guys think? Hold on a minute. Something's happening. There's no sound, but I see the judge. The judge doesn't have on his robe. He just has his shirt on. Here, I'll show you guys. But do you guys think that the reason that Athena's parents dropped the lawsuit against FedEx is because of preserving the evidence against Tanner for the criminal trial? Because remember how what we thought we knew about this crime, right? Remember that. And then I wonder if that evidence would have, if what happened in the back of that FedEx truck would have come out in that civil suit. And Athena's parents were like, we don't want to risk it. We'll wait. We'll wait until after the trial, after the criminal trial. I wonder about that. I do. All right. Well, I don't know what the judge was doing, but they're definitely not back in the courtroom. I'm going to go ahead and end this now. And I want to thank you guys all for being here today. I know this was a difficult trial for all of us. I'm not going to play the outro today. Somehow it just feels wrong. It's too peppy. This is a good thing. Or Amber says, or I wonder if they didn't because they don't want Tanner to feel like he helped them in any way. I mean, that's maybe, like when things like this happen, what is the judge doing? I'm getting nervous to walk away because let me go. Look, this is what we'll do. Let me just go over here to the court TV. Don't go. Nobody go nowhere. Hold on. Let me see something. Let me just check some things right quick. All right, hold on a minute. Give me un momentito, por favor. Actually, let me do this too. Let me check two things. Let me see. Give me a second, you guys. I appreciate your continued patience as I do my level best to get you all the information in a timely fashion. Hold on a minute. Now I forget how to do this. Shit. Girl, that's not what I wanted to do. Here we go. I had to really scroll. All right, let me check that. And let me check. So I looked on the feed from Fox 4. There's nothing pinned in the chat. Let me look at. Give me a sec. Sorry, you guys. I'm bumbling around just due to the fact that I have a cold and I can't. Also, let me just tell you something. I don't think there's anybody that actually likes to be sick, right? Like I think that I hate being sick. Well, nobody likes to be sick. But the worst part about this cold is not just the cough. The cough I could deal with. It's the stuffy nose and breathing out of one nostril at a time. The mouth breathing, just absolutely, I can't handle it. All right, there's no. Okay, hold on a second. All right. There's no verdict watch like clock on court TV. There's nothing pinned on law and crime. So I'm going to go ahead and say that I think we should be good to go. I think we're good. All right. All right, you guys. I'm going to let you go for real, but I'm not going to I'm trying to bring the hard-hitting news, coffee and skeletons. All right, you guys, I'm going to let you go. And remember, I'll be back live when there's a verdict. All right, you guys have a great rest of your afternoon, and I'll see y'all later. All right, bye.